This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an arson-for-profit scheme failed and why innocent co-insureds still have no rights to the proceeds when the fraud was committed on their behalf, and why submitting a fraudulent proof of loss voids a fire insurance policy. Plaintiffs Timeless Bar Inc. and Horseshoe Club LLC sued their insurer, Illinois Casualty Company, claiming the latter breached the parties' insurance agreement. Specifically, the plaintiffs alleged that even though the fire that destroyed their property was intentionally set by an officer of the corporation and a member of the LLC, the insurer was still obligated under the policy and Minnesota law to pay for the loss. In Timeless Bar Inc. versus Illinois Casualty Company, the United States District Court for the District of Minnesota, on May 21, 2024, in a lengthy opinion, resolved the issues as to who was responsible for the fraud and who could collect, if anyone, from the insurance claim. In April of 2016, while still a married couple, Andrew Welsh and Jessie Welsh purchased a bar in St. Cloud, Minnesota. The couple opened the business as the Press Bar and Parlor and operated it through a corporation called Timeless Bar Inc. They also set up a real estate holding company, Horseshoe Club LLC, and arranged the building purchase through that company. On February 17, 2020, a fire that destroyed the bar occurred. The defendant and law enforcement later discovered that Andrew intentionally set the fire. Illinois Casualty insured the Horseshoe Club against the risk of loss by fire and covered as an additional named insured the building owner for certain losses associated with the building itself under the policy. On February 17, 2020, Andrew Welsh burned down the bar. The following day, Andrew executed a non-waiver agreement with ICC as the authorized representative of Timeless Bar as a named insured under the policy. On February 26, 2020, Timeless Bar and the Horseshoe Club submitted the initial insurance claim to ICC via a proof of loss, seeking approximately $1.4 million in proceeds. The initial claim sought the policy limits for the building and other amounts. The claim stated that the fire was of unknown origin. Further, the sworn proof of loss stated that the loss did not originate by any act, design, or procurement on the part of the insured or the affiant, the person signing the proof of loss, and that nothing has been done by or with the privity or consent of the insured or the affiant to violate the conditions of the policy or render it void. Andrew and Jessie both signed that proof of loss on behalf of the businesses. There was no dispute that in the proof of loss, Andrew falsely stated that the fire was of unknown origin and that the loss did not originate by any act, design, or procurement of his own. Nor is there any dispute that his submission of the false claim as an affiant on behalf of the insured was in an effort to defraud ICC. The crux of the dispute, therefore, in the case was whether Andrew Welsh's conduct, burning down the bar and later lying about it in the insurance claims, allowed ICC to deny coverage to Timeless Bar and Horseshoe Club ICC argued that Andrews' conduct is imputable to the plaintiffs for purposes of all three exclusions at issue. His submission of a fraudulent insurance claims precludes coverage for the plaintiffs under the misrepresentation and dishonesty exclusion, and his arson precludes coverage under the intentional acts exclusion. As explained, the court found that there is no genuine dispute that Andrew filed fraudulent claims on behalf of both Timeless Bar and Horseshoe Club. Because he did so, no reasonable jury could find that ICC breached the policy by denying coverage under either the misrepresentation exclusion or the dishonesty exclusion. ICC is therefore entitled to judgment as a matter of law because the policy provides no coverage. He filed a fraudulent claim when he signed the original proof of loss on February 26, 2020, and May 15, 2020 amended the proof of loss. No reasonable jury could conclude otherwise based on the record available. Minnesota Statute 65A.2.01 Subdivision 3 provides that the entire policy was void if either before or after a loss, quote, the insured is willfully and with intent to defraud, concealed, or misrepresented any material fact or circumstance concerning this insurance or the subject thereof or the interest of the insured therein, close quote. The court found that even viewed in the light most favorable to plaintiffs, Andrews' false statements in the proofs of loss submitted to ICC were dishonest acts and were made with intent to defraud ICC, and his actions were properly imputed to Timeless Bar and Horseshoe Club for purposes of applying the misrepresentation and dishonesty exclusions. Andrews' actions are therefore imputed to the plaintiffs. The misrepresentation exclusion and the dishonesty exclusion preclude coverage as a matter of law, and ICC is entitled to summary judgment, which the court granted. In my opinion, arson-for-profit is a serious crime. An arson fire is a specifically named peril in an insurance policy that insures against fire, and the risk of loss of which is insured by that ICC policy. There is no arson exclusion in a fire insurance policy. Fire is a covered peril. The named insured may go to jail for the crime of arson, but that does not affect the insurance claim. Where Welsh went wrong was in signing under oath a false claim as a result of the fire. The fraud voided coverage, and no one had the right to recover, even his innocent wife and the innocent corporations that owned the building where the bar was located. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and access to the more than 4,800 blog postings. You can also subscribe to the videos on YouTube and or rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on Rumble. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.